Hi again, Attorney Steve Vonder. We're back. We are talking in this video about the office action letter. This is trademark law, okay? So we're talking about your goods, your services, your companies. You're trying to get that coveted trademark, that R with the circle around it. That's what you want to protect your service names and your product names and your company names, okay? Your slogans, these kinds of things. So without further ado, let's head to the Attorney Steve whiteboard. Okay, let's back this up here. Okay, so we're going to talk a little bit about these office action letters. Now what happens here is, let's start from the beginning. You apply for a trademark or a service mark. Okay, there's a functional difference. A service mark is really more for describing your service, distinguishing or identifying your service, whereas a trademark is to identify your goods or your products. Okay, so you have services, products. Either way, when you get to the end and you get that coveted, registered, federally protected trademark, you're going to get the R symbol. Either way, doesn't matter which way you're going to go, you're going to get the R symbol. Okay, some people tell me, well, you know, I see this little TM or the SM. What does that mean? Well, those are state law. Those are common law rights that you have, and that's not a federal protection. You do not get the same federal protection and guarantees that you do, not guarantees, the federal protections that you get with the federally registered trademark. So if you're just using your name or a slogan, a service name in commerce, and you're not seeking a federally registered trademark, the SM or the TM is what you'll often see. But when you finally get that holy grail, that certificate in hand, you're going to get the big R, and that's really what our clients are looking for. Give me that federally registered trademark, okay? So you file your application. Usually you're going to either do an intent to use, or you're actually using the mark in commerce. Intent to use, actually using. Intent to use, actually using, okay? Lots of times the companies are already using the marks, and they say, I've got a flyer, I've got brochures, you can see my company name, you can see that it's being used in commerce, and so they'll attach a specimen, okay? So you need the specimen, attach your specimen. So you apply for the mark, you think you've got something good, and you want to protect it and get yourself some intellectual property for the company. You know, for a lot of companies, intellectual property is where the value is, where the Nike swoosh, the value in that is unbelievable. It's through the roof. McDonald's, these kinds of Google, these marks that are just, you build all your goodwill into your marks. So you're applying for the trademark, the service mark. You attach a specimen. You're trying to show how you have something unique that's not out there. If you have something that's too similar to something else that's already out there, then you can be denied or refused a trademark because it's likely to confuse consumers in your different categories. It's a bunch of different categories that you can apply for. That's the subject of another video. I want to keep this one short. So let's just say you're applying. This video is about the office action letter. And let's say you get a response from the trademark examiner. It says, sorry, we cannot give you the trademark. So sorry, so sorry. So you get the love letter, okay? And it's telling you, wish we could, but maybe if you change this, or maybe if you did that, maybe if you provided us a current specimen, we could do that. Maybe if you disclaim something that's in your application, then maybe we can get it for you. Let me give you a prime example of some common ways that we see trademarks fail. For one, you can't get a trademark on a last name. If my name's Vondran, you can't get a trademark on it. Why? Because I can't protect that and exclude all other people from using the last name or the surname. So you're not going to get that. You may be able to get a trademark on a nickname. That's totally different. But let's say you are trying to seek on a trademark for sports TV. Okay, that sounds great. Sports TV. Again, always start with step one. Do your search. Make sure there's nobody else out there. But let's say you apply with sports TV, and the trademark examiner looks at this and says, sports TV, you know, it's kind of descriptive. It kind of describes what you're doing, and I have a problem with this. But you know what? If you just disclaimed the TV, maybe I would give it to you. Maybe we would allow the mark to register, okay? You may get an office action letter back that says, disclaim TV. TV is descriptive. If you disclaim that, so you're not trying to get a trademark on the whole thing, sports TV, and by the way, you wouldn't get sports TV because it's too descriptive, the whole thing. But let's say it was, wah-wah-woo sports, okay, something like that, then the TV. So they may say, disclaim the TV portion, okay? If you get rid of the TV portion and you keep it on your mark, but you would disclaim it, then maybe we will get you the mark. So, these are some common things that pop up. I have a short list over here of common reasons why trademarks may be denied. You may have forgot to include a specimen. You got to have that. Or an intent to use. If you just say, I'm going to be using this mark, I want to basically reserve it now, and I'll supplement it after the company gets up and running, then I'll give you the specimen at a later date, usually 6 months. That's something you can do. But if your mark is descriptive, you can just be denied just because it's descriptive. It describes what it is. Sports TV, it's too descriptive, okay? So if your term is descriptive, that's another thing. So with trademarks, I always tell people, try to pick something that's arbitrary and fanciful, something totally you've never heard of, like Google. Like the first time you heard Google or Yahoo, you were just like, what the heck is that? Arbitrary and fanciful names are easier to register because you don't run into this problem of the mark being descriptive. Being descriptive can kill your chances of getting a trademark. Again, likelihood of consumer confusion. So if you have your product, your name is this, or your slogan is this, the other company is in the same business. One of the big cases was, I believe it was Lexus. You have a car that's Lexus. You have a legal research company that's called Lexus. Very similar, but they were in two different categories. Okay, one selling cars, one selling information and legal cases. So they're two different categories. In that case, it was allowed because they weren't going to confuse the consumers in these particular market areas. Okay, so likelihood of consumer confusion is the key. One of the keys you want to make sure of when you're seeking these trademarks. So if it's likely to confuse the consumers in a relative area, in a marketplace, in one of these categories that you're going for, you may be denied the trademark. Again, we talked about last names, surnames, geographically misdescriptive. If you say something is made in the USA and it's something, or made in California and the company's down in Texas, not selling products in California, somebody may say, well, that's misdescriptive. You're confusing people, you're misleading people, and you can be denied on those grounds. So when you get this office action letter, you have 6 months. For my astute legal students out there, we have 6 months to respond. If you don't respond within 6 months, you run the risk of your mark being abandoned and a refusal to register. You basically end up with nothing. So if you get into that situation, sometimes we get people that have used LegalZoom or one of these other trademark firms, but when it comes to the office, they paid a low price. But when it comes to the office action letter and responding to that, they say, hey, sorry, that wasn't included in my service. And you're like, well, wait a second, I didn't get my trademark. That's when you may need to call us. You can find out more information at officeactionletter.com. That's officeactionletter.com. And this is what the USPTO, U.S. Patent and Trademark Office, will send you the office action letter, 6 months to respond. And if you make a good response, all is well. You get your coveted R. Everybody's happy. You got your intellectual property, and you can tell people, I am federally protected. Federally protected, okay? Attorney Steve Vondran here. If you need some help, find us on the web at officeactionletter.com. We have low flat rate fees for almost all of our legal services, and we pride ourselves in being a little bit different than the average law firm that you work with. So give us a call at 877-276-5084. We're happy to look at your case and work with you, and we look forward to helping you succeed in business. Okay? Thanks a lot.